If it had not been for North Mississippi Rural Legal Services, there probably would have been no access for justice on behalf of poor people and for particularly African Americans in North Mississippi. Several years ago, back at the middle of the 2000s, I participated in a program over at the Obney Center Institute for Journalism here at Ole Miss, in event, the Ole Miss School of Journalism. And it was a tribute to Dean Josh Morse. Dean Josh Morse has been mentioned many times as the person who brought these, quote, Yale graduates to teach at the University of Mississippi School of Law when he was the dean. And the program at the University of Mississippi School Law School gave birth to North Mississippi Rural Legal Services, which was then legal services for Oxford and Lafayette County. It's ironic that we celebrate the 50th anniversary of North Mississippi at the University of Mississippi School of Law, when 50 years ago, the law school booted out North Mississippi Rural Legal Services and booted out their first full-time executive director, Michael Trister, another Yale graduate who came to teach on the faculty along with a further Yale graduate, George Strickler. And they were so successful in legal actions on behalf of the poor and African Americans in Oxford and Lafayette and surrounding counties that the establishment of state government officials, local government officials, business executives decided that they wanted to kill legal services because they really didn't want support, at least public supported lawyers for the poor, to uphold justice for the poor. North Mississippi was an example of what I call an irreconcilable contradiction between the nation's pledge under President Lyndon Baines Johnson and his war on poverty, which featured such stellar social programs as Head Start and as Medicare and as neighborhood legal services. In contrast to Head Start for young children and Medicare for the elderly, legal services just rubbed the power establishment the wrong way. And the history of the troubles of North Mississippi Rural Legal Services was due to the nature of our adversary system in law, in which one party represents a plaintiff and another party represents a defendant. The plaintiff brings a claim, they bring proof, the proceedings, sometimes there's trial and evidence, and there's a decision and a determination of basically who was right and who was wrong. Now, what I cite in terms of my thesis, that legal services for the poor, which was access to justice for all, without regard to their economic means, is that legal services became so successful against, as I said, business interests and government agencies that rather than playing fair and do what they were supposed to do as our separate branch of the government, the executive branch, the legislative branch, and the judicial branch, with the judicial branch determining the legal rights and responsibilities, instead of following the law, the business and the government sources that lost because the law found they were violating the law, they decided to cut out the lawyers who were successful in representing the poor. Thus, we had a system in which the federal government said persons should have access to legal justice even when they don't have the means to pay. And therefore, the federal government will fund lawyers for the poor. This started in 1965, 66, 67 with legal services. By the mid-1970s, some of the states, such as Ronald Reagan, the governor of California, who later became a president, John Bell Williams, the governor of Mississippi, could veto these programs. These governors vetoed the programs in an effort to knock out legal services, deny people access to justice, and take away a threat to the wrongful government policies and procedures and wrongful business activities that deprive certain people of their legal rights. The legal services program went through these challenges, first with the vetoes, and then, as with North Mississippi Rural Legal Services, they found nonprofits and educational institutions, such as Mary Holmes, to sponsor the programs. Eventually, the government, realizing this inherent conflict, that it offered to pay for legal services, but the payment for legal services of the poor in funding lawyers to represent the poor and their successful results created the conflict and the backlash with the business and the government and sometimes individual respondents who lost cases. The federal government, along with primarily the powerful American Bar Association, that has always stood for access to justice on behalf of persons, especially when the government has to pay for it, perhaps rather than the private lawyers have to do it without a fee. We do have, under our Sixth Amendment, a fundamental right to a lawyer, and that's been translated into a lawyer under a public defender or appointed system of lawyers who are paid by the government because the defendant cannot pay for it. But we don't have such a legal right for a lawyer in civil cases. Again, that's why President Lyndon Baines Johnson should be given credit for the courage to influence and to persuade Congress to create the Legal Services Program. After about 10 years, from the late 1960s to the middle 1970s, Congress, realizing this conflict in what is called a grant program, a grant and aid program, decided to create an independent agency called the Legal Services Corporation. And the independent agency would receive funds from Congress to fund local legal services programs. This method of funding legal services at the local level by a semi-independent agency called the Legal Services Corporation eliminated the grant and aid program and further prevented governors from vetoing legal aid programs and further eliminated any problems with local nonprofits being willing to sponsor a grant and aid program, and to some extent prevented Congress from eliminating any of those alternative sources to sponsor programs. So now it was just the Congress and the appropriation of funds and the Legal Services Corporation. Yet that wasn't enough, as legal services continued to produce high-quality lawyers that, in some sense, were as effective as private bar. And the lawyers continued to win cases against individuals and businesses and government agencies found to have violated the rights of the poor. In many cases, racial and language minorities and women and others are protected by various laws. So then Congress decided to start chipping away the powers of lawyers. It was almost like a lawyer's body is what is equivalent to a full lawyer. And they started to cut off an ankle, cut off a leg, cut off an arm, and they came up with all these prohibitions that legal services, even for qualified persons whose income did not enable them to hire a lawyer, to prevent criminal cases, to prevent, just as an example now, school desegregation cases, legislative
Y'all won all those cases.
redistricting cases, that's right, pickets and boycott cases. Later on, cases dealing with abortions, cases dealing with immigration, in a number of instances, cases dealing with access to public assistance, backup centers with specialization in housing and economic and litigation, who did research and helped lawyers in the field become experts in various issues of the law. And in one other critical area, nonprofit organizations may participate in educating legislators to adopt certain policies and legislation. In the private world, that's called lobbying. In the nonprofit world, lobbying is prohibited. Nevertheless, nonprofit organizations may meet with legislators and staff and educate them to pass legislation benefiting their clients. And that's called public policy education. So all of these kinds of effective representation by lawyers in a profession with a professional responsibility of zealous representation and an adversary system in most instances of one party versus another party, Congress stripped legal services of most of the effective tools of zealous and competent and effective representation. So all of this comes back to my thesis that Congress and the Johnson administration really experimented with the very noble goal of providing access to justice for the poor with federally funded lawyers. Yet when these lawyers became too successful in representing the poor, Congress realized that was the irreconcilable contradiction that you can't have successful lawyers representing the poor and winning cases against the government and business and private interests, and at the same time have political tranquility, because the powerful forces that were losing utilized the advantage of their money and their influence and their lobbying to kill legal services. Legal services, in celebrating its 50th anniversary too, in 1965 to 2015, hailed their success, that they're still in business. However, if legal services were a patient, and if the doctor was examining the patient's health, it would say that 50 years of age is not old in this day and age. Yet, those 50 years, we would say, have shown on the face and the body of legal services a very hard life. They still exist today in legal services and lawyers. It still does excellent work in representing the poor. It does a magnificent job with the narrow paths that they have to represent individuals. And the future is still available to succeed, as this 50th anniversary has discussed through speakers, as other efforts around the country have shown. In order for legal services to succeed in the future, they must create a new model. And these new models are designed to raise non-government funds to provide legal services and reduce the reliance on government funds. However, it's going to take other non-government paid legal aid and defender type systems in the broader category of legal services work to fully represent the poor. Because as I close, legal services, if it's shown anything in its 51 years of existence, and North Mississippi Rural Legal Services too, in its 50 years of existence, is that there's an irreconcilable contradiction between the federal government providing successful legal representation and access to justice for the poor and a political harmony with the large governmental and business and individual interests that lose in these legal services cases.
Are there any aspects of your work that you did not talk about today that you wanted to add in the interview? Now, are we?
Yeah, just keep going. The battery died, but we're still recording.
But we still have.
Yeah, we got plenty of video.
And they can audit this.
Let me think about that last question. I know, I heard you.
Any stories you might not have been able to tell that.
Let me think about that.
Important.
Yes, I'm going to tell one more story. We have to charge and wait.
No, you're still recording on the microphone, so
It would be all right.
Just go audio.
Yeah.
All right.
Just do the
Yeah.
audio.
Thank you. Today, at the 50th anniversary and litigation conference for North Mississippi Rural Legal Services, I told the story of how I was arrested for practicing law without a license. That's already on tape. And I further told the story of how the case ended, where the state of Mississippi filed criminal charges accusing me of committing a felony by practicing law without a license. And I further told the story of how very courageous and successful lawyers for me, Mike Trister, the executive director, Ken Spriggs, the deputy director and the litigation director, filed a successful federal lawsuit to prevent and stop the prosecution against me. That federal case, called an injunction, did stop the prosecution because the judge issued an order in what is called at law a temporary restraining order until the full merits of the case be heard. Temporary restraining order is issued by a court when it meets the requirements of irreparable damage and an adequate claim at law and a balancing of the equities. If the state had convicted me of a felony and it was a wrongful conviction, I would have suffered irreparable harm in having a criminal conviction and probably being disbarred. So the court issued the injunction to allow me to present the case on why the state brought the criminal charges against me with bad faith and to retaliate against poor people and minority people who I represented because we were successfully challenging a wrongdoing. And some have asked me, well, how did the case end? Because I only left that they had accused me of a crime. I had blocked the case with a federal suit. Here's how it ended. I was arrested in March of 1970 and immediately obtained the federal court injunction to stop the prosecution. Over the next year, I continued to practice with a cloud over my head. A following year later, in February of 1971, I decided to take the Mississippi bar and become a licensed lawyer in Mississippi. I passed the bar in May of 1971. the two additional stories is that when I went to take the bar examination, the exam was given in a Holiday Inn, and there were only a handful of people in a conference room at a table that seated no more than 12 people. In most states, hundreds, if not thousands, of bar applicants are tested for the bar license. Mississippi had what is called the diploma privilege, one of only about one or two states at the time in the 1970s that automatically admitted law graduates to the Mississippi bar if the law graduate finished and received a degree from a Mississippi law school. So here I go into the bar examination, and the chairperson of the bar examination committee greets me. The chairman of the bar examining committee was a lawyer whom I had successfully beaten in a federal case in Nettleton, Mississippi. It's over there by West Point. And when Nettleton, Mississippi, finally decided to desegregate its schools, some 16 or 17 years after Brown versus Board of Education and the Supreme Court ordered them to integrate, they fired all the black administrators and all the black teachers, which was illegal action. And I brought suit, and we blocked the dismissal of all the black faculty and administrators, and we also achieved a remedy and a system on who to rehire and how teachers would qualify for rehiring, and the same with administrators. The school district lost the case on the liability that they were wrong to fire all the black teachers and administrators, and they lost on the remedy that they proposed. After they lost, they appealed to the Fifth Circuit. That's the Federal Court of Appeals that hears all federal cases from Mississippi, as well as Louisiana and Texas. We won at the Fifth Circuit. And so I had beaten this lawyer twice, once in the federal court and once in the Court of Appeals. And there he sat, presumably, with my future to become a member of the Mississippi Bar at his hands. When I walked into that room to take the exam, and any kind of grading after the exam. I should say, with a little side note, that in those days, Mississippi had so few bar applicants that they gave what I would almost classify as a college kind of political science and somewhat law bar examination. For an example, they had a question, name the 3 courts of Mississippi. Well, Mississippi was unique. Mississippi had what is called the Justice of the Peace Court, and you didn't even have to be a lawyer, but it had general jurisdiction over minor criminal and civil matters. I recall going to a Justice of the Peace who owned a gas station, and we had the court in the garage of his gas station with the lift and with the tools and with all of the mechanics of a garage that repairs vehicles. And then they had what is called the Superior Court. And then Mississippi was unique from almost any other state. They had what is called the Chancery Court. They still have it today. But 99% of all the other states have mixed law and equity together. But in any event, that's just an example. And then it had to say, or question, well, what's the jurisdiction for this court or another? So it was a kind of simple test in that regard. They had a few problems in which the applicant would have to figure out what is the law and what a party should do. Those are typical bar examination questions. This is before they had the multiple choice questions. But they did have a few multiple choice questions of their own, but they weren't necessarily scientific, and they hadn't been pre-tested and vetted around the country with all the psychometrics of testing. So anyway, that was the bar, and they basically graded it by hand. So they could have easily determined that I had the wrong answers and flunked me. But nevertheless, I passed. And even though he was the chair, so I should give him credit that he must have been fair and objective and didn't allow his biases of anything he felt against me, because I beat him in 2 cases to interfere with his duties to fairly and impartially conduct the bar exam to test applicants for admission. So once once I passed the bar, I called and asked him what was going to happen next. And he said they were going to admit me. And I thought that was kind of strange because no bar ever admits an applicant who has pending criminal charges. And I still had that felony criminal charge here in the state of Mississippi. And they have a second round of a review where they call you in and they question you on what is called character and fitness. And Mississippi never called me or never looked into the character of fitness. So I said, well, look, if you're going to admit me to the bar, then I'll probably drop my federal case that's blocking the state's criminal case. These aren't the same officials that handle each department. The lawyer handled the bar examination part. The state's attorney handled the criminal prosecution. And of course, the state attorney general represented the state in the federal injunctive action. So there were a lot of players in this process. So with that, they go ahead and they notify me that I passed the bar. And Mississippi is a what is called compulsory bar. In other words, any person who passes the bar is automatically a member of the Mississippi Bar Association. And you get a number and you pay your dues.
Right.
But you have to belong to the state bar.
Right.
Some states, a licensed lawyer doesn't have to belong to the state bar. Those are called voluntary systems. So now I'm a Mississippi lawyer. And so I'm thinking in my head that, well, maybe you can make believe I was a Mississippi lawyer back in 1970 when I appeared in court, and although I satisfied all the rules as an out-of-state attorney, you accused me of a felony of practicing law without a license. That was my thinking. And so I said, well, if you drop the criminal charges, I'll drop the, if the state drops it, I said to the bar examining person, I'll drop my injunction. So sure enough, the state, never any discussions, never any settlement. Don't do this, don't do that, don't say this, don't say that, we agree. They just simply dropped by voluntarily dismissing the criminal prosecution. And in good faith and honoring my word, I dropped the federal action. And we just seemingly decided to let bygones be bygones.
Okay. Well, that's great. Well, we appreciate you coming in today. Do you have anything else you want to add?
I just want to say that 47 years later, and having never been a resident of Mississippi since 1973, I am still a licensed lawyer in the state of Mississippi and proud of it in 2015.
Good for you.
I'm also a licensed lawyer in the state of Connecticut, and I'm further a licensed lawyer in the state of California.
Wow. Well, we're honored to have you here today.
Thank you very much.